discussing House Bill 5242, an act concerning the collateral consequences of criminal records on housing opportunities. And listening to my colleagues, and I can tell there's some frustration in their comments that they want to do something here. And just the bill is not written in a way that's conducive to good policy from our perspective. And I think that's a frustration. And that's a difficult part of this job, which is that, sometimes you are desirous of making policy because you recognize a problem, but it's very difficult to come up with the right answer. And some people might argue to say, don't let the imperfect be the enemy of the good or anything like that. But this bill is really imperfect. And I think it's dangerous, just to echo some of my colleagues' sentiments. And that's too bad, because there is a real problem here. I want to get into the meat of the bill. I just wanted to preface my discussion on it by saying that I'm very frustrated, because I would like to do something that is an actual solution here. But maybe the problem is that you're trying to put the problem on housing providers when there's no way they could possibly be the decider or the solution in a case like this. The fact of the matter is, if we had a criminal justice system that worked perfectly, and that you could know that after someone served their time that they were rehabilitated, then this wouldn't even be a conversation. We would just happily accept tenant applicants based on their other criteria, and housing providers would not even consider that as a factor. But that's not reality. Reality is that some people are going to leave incarceration reformed and better people, trying to set their life on a proper path, but other people will not. And this bill kind of says it's up to the landlord to figure that out. And that's just not fair. For one thing, I don't know how you can put that on a landlord to figure that out from a rental application. I'm supposed to take a chance on whether someone is not going to be a detriment to my business, to the other tenants that I live in my properties. So that's the problem. And if you want to solve this problem, what you've got to do is you've got to find a way to say with certainty that someone that has a criminal record, is no longer, a potential negative, by saying with some certainty that person is reformed, or there is some other mechanism that will ensure that whatever happens, it's not the landlord who's at fault. Because I think that's the problem here. I think that the concern is that if you're a housing provider and you take on a tenant that has a criminal record, if something happens down the road, you could be held responsible for that. And it's something you obviously should have known because you have this record. I'll talk more about that after I kind of get my thoughts straight, but I just want to clarify a few things that are in the bill. Just looking at it, on the very first section, on the first page, when it says conviction, on line 5 going to line 8, it says conviction means a judgment entered by court, blah, blah, blah. I think that this is where it makes it quite clear that we are only talking about felony convictions, and that this bill, in fact, requires housing providers to ignore all misdemeanor convictions. Is that correct?
Yes.
And we've had testimony during the public hearing that there are actually some violent misdemeanors. I think I remember suffocation was one of them, strangulation. I mean, that to me, those are terms that would alarm me. If I was a housing provider and I had an applicant that was convicted in a recent time frame for strangulation, particularly if you're talking about, a minor involved or something like that, to put that tenant in the same building with other tenants and make them potential victims to a future crime. Now, look, in fairness, people who have no criminal records are going to commit crimes, and you can't know or predict any of that. But at the same time, I think that putting it on the housing provider to be the decider to say, well, this particular person that has a criminal past is completely reformed and nothing's ever going to happen with them versus someone who may not be, is an impossible feat. I mean, the housing provider is operating off a background check and potentially a response to a request for information from the tenant applicant themselves. That's the extent of the information. I mean, we have, court trials that go on for months and months and months, and sometimes they convict the wrong person. I mean, this is not even close to that. This is like hardly any information at all provided. And I don't mean this in a disrespectful way, but it's obviously biased. The applicant is going to be biased in favor of themselves. I mean, it just doesn't make sense that they wouldn't. So it's not even from an impartial source. So that's a concern. So just going forward, Section 2, which is the meat of the bill, where it says new. And now it says it shall be a discriminatory practice in violation of the section for a housing provider to refuse to rent after making a bona fide offer or to refuse to negotiate for the rental or otherwise make unavailable or deny a dwelling unit to any person based on such a person's criminal record. This is kind of confusing. I tried to read through this like 5 times and try and make sense out of exactly when these time frames begin. Do these time frames that are here listing the relatively few items that a housing provider can use to make a determination, are these dates based on the date of conviction, the date of release from incarceration, or some other date? Through you, Mr. Chairman.
The 3-year period is from the date of conviction. Or no, sorry. The 3-year period is from the date of conviction, and the 1-year period is immediately preceding the rental application itself.
Right. So just thinking about that, these are relatively short periods of time. The clean slate legislation that some of my colleagues have been talking about went back way farther. So they are proposing to do away with criminal records that are fairly old, 5 or 10 years. And in this particular situation, we're going to be negating crimes that could have happened quite recently, especially when they're based on conviction. I mean, if you get convicted for a relatively serious crime, you might serve more than 3 years, and therefore, the day you're out, you're eligible. Which I think is interesting to put it in that perspective. I guess my concerns about this bill really come in the next subsection, though. This is in subsection B, little b, under section 2, starting on line 75. And this is where it says that before denying a rental application based on a criminal record, a housing provider shall consider the nature and severity of the crime. And the fact of the matter is, so that's the first thing they have to consider. But I don't know that they're going to have any detailed information. They're going to only have basically what's going to show up on a background check. And that might not tell you a whole story. The crime may be far less significant than the actual crime that was charged, or it might be much worse. It's hard for somebody to know. The next thing is the relationship, if any, the crime may have to the prospective tenancy of the convicted person. And that makes perfect sense. If it is a, white-collar crime about stealing the recipe to KFC, I don't think anybody cares about renting to that person, versus a violent offense, for example. So that makes sense. The next point really is the one that really gets me, though, which is information pertaining to the degree of rehabilitation of the convicted person. So landlords have to determine the degree that someone is rehabilitated based on having just the criminal background check. I don't see how that's even conceivably possible. And again, I go back to my opening comment, which is, I get what we're trying to do here, which is to say that, not everybody that has a criminal past is going to be a criminal in the future. Many good people, have turned their lives around. And we want to make sure they're granted a full opportunity to have the best chance to be successful going forward. And I want that too. But what we're doing here is we're putting this back on the landlord to be able to make a determination they cannot possibly make. And so what is the downside, Mr. Chairman? If a landlord gets it wrong and says, I'm going to bet on this person who committed 11 previous crimes, okay? And among them were sexual assault and maybe some other, violent crimes. And this person takes a chance on this person after interviewing them and talking about their criminal record. So they put them in their apartment building with a number of other tenants. And a year later, there is a atrocious crime, a rape or murder or something, and that person is responsible. What liability does the property provider have at that point? Can they be held liable in a court for damages?
Within the context of this legislation, that is not clear.
I understand it's not in the bill, but I would believe that you absolutely could sue a landlord. I mean, you can sue anybody, but I think you could even be successful in suing a landlord if you can demonstrate that the landlord should have known. This person had multiple convictions. They were violent convictions. Can I ask why there is no provision in this legislation to create immunity for the housing provider so that they're more inclined to take a chance on someone?
It's just not something that we have discussed previously, at least not in my limited experience in this committee, Mr. Ranking Member.
Understood, Mr. Chairman. Yeah, and I'm not even suggesting that's a good idea either, because I really don't want to have a situation where the housing provider doesn't care at all anymore because they're immune. They're like, well, whatever, we'll just take everybody. Because now that's not a good situation either. I mean, this is just a very difficult problem to solve. There's in lines 82 to 91, they talk about how an applicant's rental application may not be denied based on a few different things. Excuse me. First one is an unofficial record of arrest, or even an official record of arrest, not followed by a conviction. That makes sense. You've got to be guilty. Second, a violation of a condition of probation or from conduct criminal act if it were not prohibited by such. Sorry. And then it says a record of a conviction that has been erased. And but the last one is what gets me. It says, and remember, these are items that a rental application may not be denied based on. It says when the applicant was a minor. Now, look, I get it. But the fact of the matter is you have some minors out there right now that have rap sheets that are multiple pages long. I mean, I talked to my local police chiefs, and, they've shared with me that there are some folks that are running around that have 20, 30 crimes on their rap sheet. And they're still out there, stealing cars or God knows what. What if a minor, burns down the building that they live in, and now they're trying to, a couple of years later, rent an apartment? Wouldn't it be a reasonable thing, I think, for a landlord to be able to take that into consideration?
That is.
It's specified in the bill. It says an applicant's rental application may not be denied based on a conviction that occurred when the applicant was a minor. I'm just curious, why not? When it seems to me that there should be some situations where it would make sense to do so.
I just don't think that we should be going into the records of minors. There are many studies that people have done due to brain function and the way that people develop. It's just not something that we've thought was necessary.
Well, I can appreciate that, but I mean, at what point is somebody's brain developed?
According to many studies, that'd be around 24 years old.
Okay, but this says minor. So what if the person committed this act when they were 17 and they're trying to rent from me when they're 19?
They were a minor when they were 17.
Right, but their still brain's not fully developed, so they might still be.
Absolutely. It's definitely more developed than it was when they were 17.
Definitely. I appreciate, your attempt to defend the position, Mr. Chairman, but it's a pretty indefensible position. The idea is that you're telling someone that they cannot take into consideration information that is completely relevant. And I think any person on the street, I think even people that are advocating for this bill would have to admit that, yeah, that's in some cases it's going to be relevant what people have done. So in the next section, this says, before denying a rental application, a housing provider shall provide written notice to the applicant that the application requires further review due to the applicant's criminal conviction. And the housing provider shall provide the applicant not less than 5 business days in which to respond to such notice and present relevant mitigating information and evidence. So a housing provider does a background check and they find out that someone has numerous criminal convictions on their record, and it raises a red flag for them. They have to make a decision between this person and other tenants that don't have a criminal record. They want to do right by this person because they've served their sentence and everything else. However, now they're gonna go back to the applicant and tell them, say, look, you have a long criminal record. I need you to respond and explain to me why I shouldn't take this into consideration. Can I just ask, Mr. Chairman, I mean, what would you expect is going to happen at that point?
The tenant or the prospective tenant would have the opportunity to plead their case, and then the person who owns the unit, the landlord, the property owner, would be able to then accept or deny based on that information.
Are we to expect that this person's going to be 100% truthful about their situation? I'm sure some people will be, but what if they actually are a criminal?
I think you'd have to take into consideration what the documentation is and who it comes from, whether it be that person themselves or references.
Can I ask, Mr. Chairman, is the applicant under oath when they complete this documentation, or do they have to sign something under penalty of fraud or anything like that?
Under the text of this bill, no.
So there's really no binding protection for the property owner to say that this person is not just totally lying to them.
No, but the property owner has full right to deny based on any information that they receive.
I appreciate you saying that, Mr. Chairman, and I'm getting there. Because full right to deny would imply that somehow the landlord has the say in this matter, and ultimately they can deny an applicant without fear of retribution. And obviously that is not true, because the whole rest of this bill, the next 10 pages, is dedicated to what happens going forward, and effectively is completely one-sided, with the potential being that the landlord loses their rental income, they incur numerous court costs and legal fees, and ultimately can be charged with discrimination. So they really don't have full say to do anything. So it says in line starting 109, it shall be a discriminatory practice in violation of the section to discriminate against any person in the terms, conditions, or privileges of the rental unit, or in the provisions of services or facilities in connection with the rental of such dwelling unit because of such person's criminal conviction status. So now you're effectively creating a mechanism where the housing provider could be charged with a crime, or not a crime, but can be held civilly liable for discrimination. I also noticed that just squeezed into the end of that paragraph, it says that that it's a discriminatory practice, not just to prevent someone from having access or certain privileges at a dwelling unit, but it also to inquire about an applicant's prior arrest, criminal charges, or convictions on initial application for rental of a dwelling unit unless required to do so by federal law. So this policy is also going to prevent a housing provider from even asking the question about whether someone has a criminal record?
Unless specified in the 3 and 1 year provisions in the beginning of this bill, that is correct.
Well, I don't.
On the initial application.
This is am I misunderstanding that this is in a subsequent step to the initial application that this is prohibited, Mr. Chairman?
I don't think it's a subsequent step. However, if you look at the section, it's inquiring about the initial application for rental, and specified in the beginning sections of this bill, you can look at those 3 year and 1 year look back periods.
Yes, I mean it's clear that you can run a background check and you can contemplate those items, but that's different than having the ability to ask the question, because this basically says you can't even ask the question. It says you can't even, it's a discriminatory practice to inquire about an applicant's prior arrest, criminal charges, or convictions on an initial application for rental.
Yes, that's how it reads.
Okay. So, I mean, this is pretty one-sided, much like the other bill that we had earlier today. And because the way this has been presented, Mr. Chairman, is that somehow this is being very fair. You know, that the landlord has an opportunity to, review the person's record and to ask for more information and so forth. But effectively, what's happening is the housing provider is being told you cannot ask, and if something shows up on the criminal record, you have got to make a determination without any real information about what you're going to do. And if you are leaning towards not accepting the person, then you've got to give that person an opportunity to make their case for why you should accept them. And then if you deny them that, then the process goes before an administrative body to make a determination. And ultimately, the determination, if it doesn't go in favor of the housing provider, they're going to be guilty of discrimination. So, I mean, if you're a housing provider, how do you take that risk?
That's more of a philosophical question.
Well, it's not just philosophical. It's in this bill that's about to become law.
No, how they take that risk is not in that bill.
I understand that. But the fact that they are going to be taking that risk is undeniable. And I think that's a large concern. I think that reading through this and understanding the potential for the interaction with the Commission on Human Rights and Opportunities, the potential to end up being fined or worse, to be categorized as someone who has committed an act of discrimination, the fact that the Office of the Chief State's Attorney may be involved to do an investigation against the housing provider now. And I believe the Attorney General's in here, too. I mean, we got the whole lock, stock, and barrel of the state's criminal justice empire stacked against a housing provider simply concerned about putting somebody who has a criminal record into an environment that might cause a problem. This is a pretty hard to believe bill, Mr. Chairman, and I say that being probably as sympathetic to anyone about someone who has been incarcerated and trying to get their life straight. But I just can't look at this bill and ignore the reality of what is being asked here. Before I make a closing statement, I want to ask another question too. On line 41, well, it's this little subsection 8, where it says housing provider means a landlord, an owner of a dwelling, an agent of such a landlord or owner, and then it says a real estate agent, a property manager, housing authority, etc. So why is a real estate agent included as a housing provider here?
Take a quick recess.
Yeah, this small section which defines housing provider includes obvious people like the housing provider themselves, the owner of the dwelling, or an agent of the landlord acting in their capacity as speaking on behalf of the owner, and a property manager, which would be the same thing. But it also says a real estate agent, and I'm just curious why that would be. Real estate agents traditionally are not making a determination about who a housing provider accepts. They may collect information, but they're not engaging in the actual selection process.
I think real estate agent is added in this section to protect in the case that a real estate agent is the one distributing rental applications.
So a real estate agent could potentially end up embroiled in this situation and be accused of discrimination if a housing provider ultimately doesn't accept a tenant applicant because they have a criminal record?
In a situation where they are giving out the rental applications, possibly.
Well, I can tell you. I mean, I'm surprised that we didn't have any testimony from the real estate organizations in the state, because I can tell you, as a licensed real estate agent, I don't know, that's alarming to me. I may just decide I'm not going to ever engage in another transaction involving a rental. I mean, the fact of the matter is that the real estate agent is operating on behalf of a owner, housing provider, and that person is the decider. They're the person making the decisions. The real estate agent is just a facilitator to advertise a property, maybe distribute an application and return it back to the housing provider, but they're not making any distinction or determination. If the housing provider hands a real estate agent an application and asks about criminal record, because they be, as it says in the section I was referring to, on lines 109 through 124, where it says that it's a discriminatory practice in violation of this section to inquire about an applicant's prior arrests, criminal charges, or convictions. So that would mean that if my landlord client hands me a rental application and says give it to the tenant, and it says on there, do you have a criminal record? Now I'm guilty of a discriminatory practice?
Yes, you distributed the application.
Interesting. Do you know if is there any way that folks that work as real estate agents in Connecticut are going to be informed that the dissemination of a document asking about a criminal record is a discriminatory practice?
That is not specified in the legislation.
It's very concerning to me, because I can see, and this is something that maybe is not going to resonate with people who have not followed our state government. What is this horrible noise going on? Oh, I thought it was something mechanical going wrong.
That horrible noise.
They didn't expect us to be here this long.
It is the last of Black History Month.
Yes.
Extra
Okay.
day.
Well, from here, it does not sound like drums. It sounds like we're behind a Yes. Good idea. Okay. Anyway, Mr. Chairman, I'll just continue by saying that I think that there is a series of events that is laid out in the later sections of this bill about what will happen to the housing provider or potentially a real estate agent or some unknowing assistant to the landlord who hands out a form. You could really end up having some serious legal problems without any ill intent whatsoever. And that is deeply concerning to me. Is there a reason why the so much legal ammunition, as I mentioned, CHRO, the Office of the Chief State's Attorney, the Attorney General, I mean, this is all being brought to bear on a housing provider over the issue of whether or not someone with a criminal record actually might be suitable for housing. It's not over any other type of discrimination. And simultaneously, the housing provider is not receiving any legal protections from anyone. What's the reason for that, Mr. Chairman?
I think the intent is as much protection as possible for the prospective tenant.
I hear you. Okay. I guess that's my answers I'm going to get, right? I'm going to do my best to make a few comments and wrap this up, and I'll try and do that to the rhythm that we're listening to. Yeah, I don't know if I can keep up. That's a pretty high tempo out there. So, much like the other bill that we reviewed today, this bill is problematic for a lot of reasons. It interferes with a private contract between the landlord and tenant. It ignores the property rights of the housing provider. It infringes on association again. I would consider it a constructive taking again because there are parts of this bill which effectively prohibit the housing provider from being able to determine how their own property is used. The fact that it does not allow, number one, that it becomes a discriminatory practice to even ask if someone has a criminal record is extremely surprising to me because for eons, it's been perfectly acceptable for someone to ask whether someone has a criminal record as a perfectly legitimate question to find out if someone's suitable for housing. And suddenly that's not a legitimate question any longer. And to go so far as to say that crimes that may have happened yesterday that fall in the category of misdemeanors but might still be as violent as strangulation or I saw something else about, what was it? Assault of an elderly, blind, or disabled or pregnant person. That's not supposed to factor into your calculus to determine whether this person is a suitable tenant. That's absurd. And any reasonable person can see that on their face. The timelines for major felony convictions are also too short. There's nothing in here that recognizes that recidivism is actually quite real. I know I'm leaning very hard on the negative side of the potential applicants here, but I'm going to be very fair to them in a moment. But I want to just point this out that recidivism is real. And statistics on it show that a great many people that serve time in prison end up going back to prison. Now, and that may be because they don't have the proper chances when they get out. But the fact of the matter is that only some that happens to and others do not. And this bill effectively creates a protected class for criminals and people with criminal records. And the way it does it is by putting it on the housing provider as if there's some magic person that's supposed to know that this person is actually a good person versus this person that is going to go back to a life of crime. They're supposed to know that. And if they guess wrong and they say that I looked at this person's record and I saw that they have a dozen different violent crimes and a pattern, and when I met with them, I got a bad vibe. When they go to make an issue of it, they are going to end up against the entire state government's arsenal of criminal justice representatives, the attorney general, the chief state's attorney, the CHRO organization, etc. Obviously, the game is rigged. And any landlord is going to say, I'm not taking any of those chances. I'm accepting every person. And I'm no longer going to even bother doing criminal background check. I think that's effectively what you're going to create with this legislation the way it is. Is that what we want to see happen, Mr. Chairman? Do we want landlords not to do criminal background checks at all?
I think the intent of the bill is what's written in the bill.
Well, what's written in the bill is enough to scare anyone into compliance, in my opinion. And I'm quite certain that's the way it's going to play out. There was a lot of very emotional testimony on this bill. And I had some very nice conversations with folks that are advocating for this legislation. And I would be lying if I didn't say I was sympathetic to them, because I just can imagine if I ended up in a bad situation in my life, committed a crime, served the time, and then got out, I would want to be treated fairly afterwards. And I can understand how people want that. The problem is that not everyone who commits a crime is going to be rehabilitated. And the landlord is not the person to ask, because they have no way of knowing. There is just zero chance that they're going to be able to figure that out based on the information that they have. And the people that are drafting this bill and putting this forward as a potential law know that. And it's unfair. It's unfair to put them in that position to be the decider of who actually is reformed and who is not. And then to do nothing to protect them from liability if they get it wrong. If you get it right, the best thing that can happen to you is you don't end up getting in trouble for discrimination and no one else gets hurt. But the odds of that are much less than one of the other options, which is you end up in trouble for discrimination or something bad does happen. It's a very difficult situation. I just want to say a couple of other things, too, which is that, you know, criminal records are part of the penalty for committing a crime. They are. Otherwise, they would not exist at all. When our criminal justice system was created, they would not have kept records. They would have said you served your time, and that would be the end of it, and there'd be no record of it. And I understand that we're attempting to go back that way with policies like Clean Slate and even the policy that is before us. The problem with that is that criminal record history is a reliable source of information to predict future activity. Now, some people may not want to accept that, because obviously there's good people that will get out of prison and never commit another crime. And more power to them. But the fact of the matter is that they probably are in the minority. And to ignore that and to pretend that that's not true, I think is dishonest. I also want to take issue with some of the testimony we heard where people said, you know, why do I have to be punished for this for my whole life? I already served my whole time and everything. I'm like, well, I would ask that person, did you or did you not know that when you were committing your crime that you could get caught and go to prison for it? And I think they might say yes. But I'd also ask them, did you not know that once you went to prison for it, you'd have a criminal record that would be held against you also? And I think that they would have to honestly answer yes too. So I'm just being fair, because one thing that really is important to me is personal responsibility. And I get people that want to be treated fairly because they're good people. and I want that too. But you got to take responsibility for your own actions. And to try and suggest that somehow other people are being unfair because they're using your actions against you is just not true. I get that somebody said people don't want to be in jail. And no kidding. I understand that people grow up in bad circumstances, and sometimes, crime is one of the options that they have. But I would point out that not everyone that grows up in a inner city neighborhood or in a bad environment ends up a criminal. Plenty of people never commit a crime despite that. All right, so that's me being harsh. Now I just want to be a little bit sympathetic and say that, look, I want to be able to vote for a bill like this. I want to be able to say that we have reached a point in our society where we can say without any doubt that once someone has served their sentence, that they're rehabilitated and that there's no reason to be looking at anyone's criminal record. But we're not there. We just aren't. If there's any data to look at about recidivism or the past crimes being a predictor of future crimes, it will prove to anyone that looks at it that the odds are not good. And the way this bill is drafted, it puts all of the responsibility on the housing provider to make the determination. And I called them a magic person before, because that's what they got to be. They got to be a magic person. They got to have this magical power to be able to decide whether someone is going to be good for the rest of their days or not. Permanent, like we talked about before, Madam Chairman. Everlasting. And I don't know that you can do that. And it's so unbelievably unfair to put that on the landlord. Why don't we have some other proposal that actually creates some other mechanism to determine whether or not someone's criminal past is relevant in a housing situation? If there is such a desire to provide this housing, then why isn't the state requiring an increased role of the housing authorities that we heard about earlier that provide such amazing quality of life and opportunity and places to live? That seems like a reasonable mechanism to me. If the state has the resources and these housing authorities have so much money that they can start expanding out of their towns and providing housing, are they under the same rules as a private landlord in this proposal, Mr. Chairman?
No.
How do those rules differ for housing authorities?
For one, there are differences in terms of what you can look at in terms of registries, which we talked about earlier.
Did the housing authorities get to look at more or less?
More.
So they get to restrict more people than a private landlord. Is that correct?
Any public housing, yes.
Okay, keep going. Keep going, rather.
Keep going in what sense? Sorry.
I had asked you for the ways in which a housing authority was treated differently than a private housing provider.
Just give me 1 second while I find the section. The provisions of this do not apply to public housing who has a conviction for the manufacture or production of methamphetamine in the premises of federally assisted housing, to a person subject to lifetime registration requirement, which we just spoke about, under state registration program, and nothing in this section shall be construed to limit the applicability of 24 CFR 960-204 or 24 CFR 982-553 regarding public housing authority.
Well, that clears it up. Yeah, I didn't go back and look at what these regulations are, so I don't know. But based on the first thing that you listed and possibly these other items, it's quite clear that private housing providers are going to be required to take more applicants with criminal records than public housing providers. And that doesn't even begin to make sense to me, that we would be making policy that says that the private housing provider that has liability for what happens in their property, that could be sued, that could lose everything, has got to be put in this position of being a magic person when there's public housing that could fulfill the same exact role. Forgive me, Mr. Chairman, I have a lot of notes because I did a lot of things earlier. And I'm not going to spend any more time repeating a lot of stuff that I've already said today. All of the same things that I referred to in Senate Bill 143 regarding the government putting weight on the scale in traditional private housing contracts, the interference with property rights and so forth. All of that is the same. We've discussed it at length. This is another bill that is going to adversely impact the ability for housing providers to provide housing in the state, period. And as we discussed earlier, when you do that, you end up with less housing. So if the goal of this committee is actually to create more affordable housing opportunities, this bill is the last thing that they should be doing. I am going to close by saying that I am going to continue to rack my head around how we're going to figure out a way for people who want to turn their lives around to do so without having to carry a stigma that's unfair. But the problem is that is something that can't happen magically, as this bill is attempting to do. And as a result, I've got to vote no on the bill today, and I'm sorry about that. But I am hopeful that the conversation will continue, because I don't think that this bill can pass and become good policy the way it is. We need to talk about this more, and we've got to find a way to make this a bit more reasonable and achievable in the real world. Thank you, Mr. Chairman.
Thank you, Senator.